possibly can. So with that explanation, I'll call the first case on the docket. It is from Lyon County, and it's actually a consolidated case. It's 129090 Emporia State University versus Professor Rob Catlett et al. And the appellant is Emporia State University. Who do we have here for the appellant?
Morning, Judge Malone. Clayton Kaiser on behalf of appellant, Emporia State University.
And
Your Honor, I would like to reserve 3 minutes for rebuttal.
that is granted. And the appellee?
Morning, Your Honors. J. Philip Gregson appearing on behalf of appellees. And if I may, Your Honors, also appearing are three of our clients, Professors Michael Malone, Charles Emmer, and Rob Catlett. Thank you.
All right. Mr. Kaiser, whenever you're ready.
Good morning. May it please the court. This is an administrative agency appeal relating to employment decisions that Emporia State University made with regard to employees pursuant to the Kansas Board of Regents Workforce Management Plan. Pursuant to that plan, there were three and only three grounds upon which administrative relief could be granted to the challenged professors. Here, however, administrative relief was granted on a fourth unenumerated ground, namely the notice that the professors received. As noted,
One of the grounds is that the termination be substantially compliant with the decision-making framework, right?
yes, Your Honor.
Isn't the notice part of the framework?
Your Honor, respectfully, I take issue with the premise of that question, at least the first part of that, with regard to the action. What the policy actually says is that with regard to the decision to suspend, dismiss, or terminate. And basically what happened at the OAH as well as the district court is there was a conflation of this notion between what a decision is and what a notice is. And that's important because in normal parlance, when someone talks about a decision, they don't use decision and notice interchangeably. For instance, when I'm deciding about what to go or what I'm going to eat today at lunch, I don't say that I'm going to notice between Burger King and McDonald's. Rather, what I say is I'm going to decide between Burger King and McDonald's. And as you see in the workplace management plan, as well as in the framework that ESU adopted, is that when they meant to talk about notice, they used the word notice. And when they meant to talk about decision, they used the word decision. So this normal parlance that we typically use with regard to notice and decision is carried forward in both the policy as well as the framework. And so, Your Honor, with regard to whether or not the action is consistent with the framework, we would push back on the notion that it's the action that you're looking at as opposed to the decision, which is the actual word used in the plan as well as the framework.
How would they know if the decision was correct if they didn't understand what the notice of the decision was going to be in the first place?
Yes, Your Honor. And that is exactly what the process is intended to afford here. So for instance, let's say you are unfamiliar, you can't tell from the notice, even though we do push back on the notion push back on the notion that the notice was insufficient, because it does. It specifically says in each and every one of the termination notices, Your Honor, it says, and I quote, "Due to extreme financial pressures accelerated by COVID-19 pandemic, decreased program and university enrollment, continuing and ongoing increases in the cost of operations across campus, and substantive changes in the education market in place," or end quote, "the professors are being terminated." So
what does that last part mean, substantive changes in the educational marketplace? What does that mean?
The pressures that had been existing prior to COVID-19 and then were manifested or accelerated or aggravated through COVID-19. And so the same...
What pressures?
I'm sorry, Your Honor?
What pressures?
With the financial pressures, for instance, the change in education with regard to one issue that was noted in both the K-Board's discussion as well as in ESU's discussion with faculty and of students is the fact that students are changing their interests. So for instance, historically, students would attend universities in person, whereas now, as we learned through COVID and a myriad of situations, that changes to where they could do it online or residential or not residential, but traveling. And so the historic programs that they had used as well as majors were shifting. And that's what ESU did through this process, was determine what's best for us and our long-term viability.
Okay, so you're saying that what that meant was fewer students were enrolling in the programs that these professors taught.
Among other things, yes, Your Honor.
Okay, so your contention is that you've said that they were fired, their employment was terminated pursuant to the plan. And the plan required that the professors be given notice of the reason for their termination.
Yes, Your Honor.
And your contention is, though, that there's no mechanism by which the professors could say that your notice didn't comply with the plan.
No, Your Honor. And there was the process. So as Your Honors are aware of through the factual record, is that the administrative hearings did occur. And so to the extent there was any question about the notice that you received, so for instance, again, with each one of the letters that I just discussed, there was this statement with regard to what this was due to, but it also went on to recite specific factors that were listed in the framework. And among others, this factor was listed in each and every one of the letter, and quote, it's the restructuring of a program, department, or school as determined to be necessary by the university, end quote. And so you do have those two specific things in every one of the notices that was given. And to the extent, and to your point, Your Honor, to the extent there are questions about, what are the reasons, I want to kick the tires to see if there's support for that, that's what the hearing was for. In each one of these cases, the professors submitted their briefing, and in response, ESU submitted their briefing. Again, it's a very fulsome briefing, 21 pages essentially in each one of these cases, in which there was single-space rationale given for each one of the termination decisions. And then approximately at least 2 months after that was received, there were these hearings.
But there was no discovery, right?
No, Your Honor.
So that's why the appellees are arguing the notice was important. Let me ask you this question, and I get your argument that that insufficient notice is not grounds to appeal. I get that argument, but
Sure.
let's go to the last part of your argument where you say the notice was sufficient anyway. All right, I'm looking at Professor Catlett's notice here just as an example, and it gives all 9 of the factors to terminate him. I presume Professor Catlett wasn't the only math professor at Emporia State, correct?
That's correct, Your Honor.
All right. Looking at this from Professor Catlett's point of view, if I got this notice, the first thing I would want to know is how come I'm being terminated and not one of my colleagues? So how does this notice explain or answer that question for him?
And this goes back to, I think, kind of the fundamental issue here is who decides what's best for the university, Your Honor. And so what happens here is the ESU made the determination after going through this process that we needed to restructure, make programmatic decisions or changes in our programs. And so with regard to Professor Catlett, as well as the other professors in the math program or math major, they decided we choose to terminate this particular professor.
But he's got a right to appeal this. The appeal process is laid out in the framework, right?
That's correct, Your Honor.
And he's got no discovery. So how does he appeal this based on this notice?
So to the extent that Your Honor is getting to sort of due process concerns or other sort of concerns that he may have.
I'm trying to follow your framework.
Yeah.
I'm not getting into due process.
Well, the way that you would do that potentially would be through some sort of court action. But that does not mean that you get to expand the jurisdictional limits that are granted or afforded to the administrative hearing or agency, which is what we have here. There are 3 specific grounds. Again, if the Kansas Board of Regents or ESU intended for the process or the notice to be subject to administrative appeal, then they could have said that.
The process is subject to administrative appeal through the second prong, the substantially complies with part.
Again, Your Honor, what we believe is the correct interpretation of that first ground, is it substantially consistent with the framework, is again, we're focusing on the decision.
So whether the decision to fire math professor A over math professor B is consistent with the framework,
Yes, Your Honor.
that would need to be something that's appealable
It would be
in the decision.
with regard to the underlying decision.
Well, the decision is here. This is the decision
Yes, Your Honor.
that's given right here. So that decision has to comply with the framework.
Yes, Your Honor.
And what we're saying is it's difficult to discern how this decision complies with that framework.
Understood, Your Honor. And again, I think to the extent that there is some claim with regard to the process or the notice.
I'm not saying the notice has a bad date. I'm not saying the notice is missing an indented paragraph. What I'm saying is, does this notice comply with the framework for the termination?
Our position is yes, Your Honor.
Okay.
And even to the extent that it does not, there's two reasons in which it doesn't grant relief in this case.
Okay.
So again, it does comply with regard to adequately giving you notice. But secondly, again, whether or not it's adequate or not adequate, that does not provide a basis for administrative review. And then second, to the extent that there was any deficient notice, as this court said in Hine versus USD 238, is that does not provide a base for get substantive relief, which is what effectively the OAH as well as the district court did here. And so, as I see my time is waning, Your Honors, what ESU respectfully request here is that Your Honors reverse the decision made by the district court and reinstate the termination decisions that were made with regard to the professors in this case. Thank you.
You still got, I don't mean to cut you, but you got 3 minutes on top of
Oh,
what
3
the
minutes.
clock says.
Perfect.
I'm interested in the Hine case and why you think it affords you relief here.
Yes, Your Honor. So with regard to Hine, obviously it's a little bit different in the sense that there it was dealing with the statute as opposed to KBOR's policy. But at the end of the day, there was no question in Hine, the same way that I don't believe there's any question, or at least in this appeal, there's no question that KBOR was the proper entity that was imbued with the ability to make decisions as with regard to tenure. KBOR is the one that granted tenure. KBOR is also the one that has the ability to change tenure. I don't think anyone's challenged. I don't think that's properly before this court. And so with regard to the fact that there's a potential distinction between which body came up with this law, again, I don't believe that that's a way to distinguish Hine. And so what we're left with Hine is Hine specifically said, in that case, the Court of Appeals questioned whether or not the notice was actually sufficient there. For instance, there was a piece, I believe it was, the notice did not have any language with regard to your appellate rights. And so under that statute, that deficiency was deficient. But nevertheless, the court went on and said that the process that you were afforded and the process that you exercised during that administrative appeal was sufficient to cover and therefore mooted.
Into due process in that one.
No, actually, when you look at it, Your Honor, because that's what it seems like when you first read the case, but as you go through, there's no language about constitutionally protected rights. There's no question about whether or not there's a property right. They're looking solely at the statute and determining whether or not, based on an alleged violation of the statute, there's any relief that could be afforded to that teacher in that case. And ultimately, the Court of Appeals said no. And so from our perspective, Hine versus USD 238 is on all fours with this case, because to the extent there is any deficiency in the notice, Hine would dictate that that does not provide a grounds in which to grant substantive relief. And so for us, Hine, again, provides a third basis, even though we don't believe you need to get there, because on the first ground, with regard to the fact that the OAH and the district court exceeded the administrative agency's jurisdiction and the notice was sufficient, even if those, in addition to those two grounds, you also have the third, which is Hine versus USD 238.
Well, let me ask about Hine. I get the fact that if one of the professors had appealed on the determination on a substantive ground for termination, then they've waived any notice deficiency because it doesn't matter. They got their appeal anyway. That's what Hine says. But here, the sole basis of the professor's appeal, or at least the basis of the ruling in their favor, was the notice was deficient in the first place. So my question is, how can an appeal challenging the sufficiency of the notice be considered a waiver of notice?
And again, I think that's kind of in my mind what is thinking through this is that that's sort of the distinction between sort of a substantive and a procedural concept. To where here, if it was just a standalone, you get notice and that's the end of your relief, then potentially that would be a different argument than we have here.
You would at least agree, I'm sorry to cut you off, but you would at least agree that Hine has that factual distinction.
Well, as I read Hine, Your Honor, I believe that in addition to the notice piece, there was also substantive grounds. And I think here as well, in addition to the fact that they claim that the notice was deficient, they also claim that, hey, by the way, substantively, your decision doesn't add up because my program was A, B, and C. And so I think they take issue both procedural and substantive. And so to me, Your Honor, the distinction between Hine, while certainly the OAH's decision was based solely on procedural grounds, which again, we believe was error. There was also substantive grounds. So I don't believe that is a ground on which you could distinguish Hine versus from this particular case.
Because they argued the substantive ground? I mean, the substantive ground wasn't the decision, though.
With regard to in this case, Your Honor?
Yeah.
That's correct. And so
So because they had the opportunity at that hearing to say, oh, none of these 9 reasons applies to me, then you're saying Hine is distinguishable?
no, I would say Hine is directly on point here, because what I believe Hine illustrates is that to the extent there is any sort of procedural deficiency that you notice in a notice, that is remedied through the process.
And okay, all right.
All right, thank you.
No further questions. I
Still
reserve the
have
remainder of my time.
Rebuttal time.
Thank you.
May it please the court, your honors, counsel. Your honors, what's really gone on here is prior to any action being taken here, there were policies in place both at KBOR level and ESU level to address any exigent financial situation. They were already in place. For whatever reason, which we don't need to know in this particular forum, they got together, the Board of Regents, ESU, and agreed to issue terminations based upon the framework. So they dispensed with the rules that applied prior to taking action, created their own rules, which frankly we thought were unfair. Nevertheless, our clients participated in the process that Emporia State came up with, that they drafted, that we had nothing to do with. They contracted with OAH, which we had nothing to do with. They conducted these hearings preceded by what the discussion has been about the notice versus decision, which frankly, I consider myself relatively intelligent. I'm not following that distinction. They got notice that they were fired, and it could have been for any number of 8 reasons. And then they were told, without any specificity, tell us why you shouldn't be fired for any of these 8 reasons. And then we, as ESU, get to respond to that.
Now, I understand that you think that this is unfair, but does that comply with the plan that was approved by the KBOR? Does their decision to terminate for these 8 reasons comply with that plan?
The ALJs clearly found they did not. And absent some substantial competent evidence to overturn that, I believe those decisions need to be affirmed.
It's a legal question, isn't it?
Yes,
So we have de novo review.
Right.
in part. Now, the judge got to hear the oral argument, because it certainly wasn't a hearing what we typically think of, and made a determination based upon the oral argument, which is, that was the ALJ is free to consider how those arguments were presented.
And we're
those
free to
particular-
ignore their legal analysis. And so I'm asking for your legal analysis of why this termination decision does not comply with the plan.
Because the plan does not afford them a legitimate opportunity to respond to why they were being terminated, under the guise of being presented with a procedure that they were told does do that. The entire process was developed to look the opposite of a due process hearing. The opposite. We're going to play hide the ball on why we're firing you. You can't ask us any questions about it. You can't call any witnesses. You can't test all these affidavits and additional documents we threw at you before you rolled into the hearing. That's why the ALJs looked to the substance over form and decided not only did they not comply with the framework because of the deficiency in allowing them an opportunity to respond, they also found that the actions were arbitrary and capricious in many instances, which are exactly 2 of the reasons set forth in the framework that afford jurisdiction and authority to the ALJs to do what they did.
Well, I thought most of the ALJ orders relied just upon notice. I seem to recall one of them throwing in arbitrary and capricious, but my recollection was this whole thing was about notice.
I don't disagree with that, Your Honor. But what I believe they did was because of the notice, they're claiming that it didn't comply with the language of what a notice should have been, which was to
Framework.
tell them why you're getting fired. That's all. That's all. That's all our clients ever wanted, was give us an opportunity to say, as was brought up, why me and not Professor John down the hall? Why not? It would have been fairly easy to provide whatever information they actually had. In any event,
Yeah, the 7 professors have been reinstated while all this is going on, right?
yes, Your Honor, and I'm glad you brought that up. If you'll take a look at the framework when you get an opportunity, the very last sentence of the framework, an employee who wins their appeal will be entitled to reinstatement, back pay, and restoration of other lost benefits. These decisions were over 2 years ago. While they're getting their paychecks, my clients have never been allowed to go back to work. Never. As I sit here today, they don't have the opportunity to continue all of the things that they would have to do to keep tenure. They can't teach there. They can't do all their research under the available ESU resources. So we're here arguing, and ESU's position, hey, we complied with this procedure we came up with. It's a little disingenuous. They still
None of
haven't
that's
complied with it.
before us though, right?
Correct, Your Honor.
All right.
I understand. Your Honors, each of our clients attended the hearings. Some objected, some requested to do discovery. All of that was denied. And again, Emporia State set the framework. My clients complied with it. Emporia State doesn't like the result now. In order to overturn the decisions in this situation, I believe the court has to find that there is no rational basis for the interpretation of notice in the plan here. So we had 7 ALJ decisions read the plan the way I read it, my partner Amanda Vogelsberg read it, the way the district court read it. And that is, hey, the notice and the decision are one and the same. You laid out the reasons for quote unquote terminating them and did not provide them a substantive opportunity to respond. And that's all that was necessary here. Your Honor's absent additional questions, that's all I have.
I'm not seeing any, so you don't need to use all your time.
That's good to read your room. Thank you, Your Honor.
Thank you. Mr. Kaiser.
Thank you, Your Honor. 3 brief points. One deals with what the underlying decisions were based on. 2 is sort of the standard that Your Honors will be applying here with regard to this appeal. And then 3rd with regard, sort of a factual question that Your Honor had, Judge Malone, with regard to Professor Catlett and sort of the rationale for making the termination with regard to him. Starting with the question of whether or not the OAH and the district court's determinations were based on the notice as opposed to some other ground, I believe it's clear as you read the KJA orders that were entered by the district court in each one of the appealed cases, and I quote, this provides the basis for what was actually the underlying decisions. And there in all the KJA orders, the district court said, and I quote, the insufficient notice therefore was substantially inconsistent with the ESU decision-making framework as approved by KBOR. Therefore, the court denies the petition for review and all relief requested therein, end quote. So, and that comes from, among other places, volume 1 at page 207.
If we agree with that, though, we don't have to base it on the same decision. We could say they were right for the wrong reason, couldn't we?
You could if there was an alternative ground on which, Judge Hurst, that you could do that. From our perspective,
Substitute the word notice in that for decision.
yes, Your Honor. If Your Honors, well, in that case, Your Honor, you would be basically reviewing the decision substantively, which the AOH and as well as the district court never did here. And so we would,
So you're saying that the decision substantively, for example, the 8, 9 reasons, that stating the decision is different than me figuring out if you could financially afford the math professor versus a different math professor.
absolutely, Your Honor.
Okay.
And that is, I'm sorry.
So the contention is the plan doesn't require you to state the decision.
No, Your Honor, with regard to whether or not the plan requires you to state the reason or state the justification, that may provide a basis for some other type of claim, but with regard to an administrative appeal, you are stuck with the 3 grounds that KBOR as well as the
So
framework provided.
how would they object to whether or not you followed the plan?
Well, I
in
think
your statements?
potentially, Your Honor, they would do what they've done in this case, which is they filed a separate lawsuit challenging whether or not the notice and the process that they were afforded with regard to their alleged property right was sufficient. And so while there may be some alternative ground, that the fact that there is an alternative ground does not basically enlarge the jurisdiction that the OAH had in this particular case, which again, our position is it's limited to those 3 enumerated grounds, all of which deal with the underlying substantive decision. And there's nothing in the record with regard to the OAH making a decision as to whether or not these underlying decisions were substantively correct. Rather, it was all based, as the district court said, on the alleged insufficient notice. And for that reasons, Your Honor, we respectfully request that you reverse the district court and order or instruct the OAH to reinstate the termination decisions as Emporia State has asked here. Thank you.
All right, counsel, thank you very much for your briefs and your arguments. As I said earlier, we'll get a written opinion out to you just as soon as we can.